watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. Today's show will discuss updates to family law. With us now is attorney Bill Jones of the Jones Law Firm. Bill, thanks for being with us. And
congrats on your new season.
Oh, thanks. You know, and it's one of those that this is the time of year that we try to update people as to what has changed in the different areas. And
the legislature generally rolls out some new changes, and it's something that you and I get to crack open a book or look at it online and try and see what has changed. And I figured today we could kind of highlight some of the more drastic changes I think that are going to affect people. Something near and dear to most divorced people's hearts is child support. So I figured we'd cover that first. Let's go back though to kind of talking when the big changes started. So it used to be that we would look at a parent's income, and we would just take a flat percentage of their income, and that was child support. And in 2005, we updated the law. We added this new child support calculator. And you can go online to tn.gov and download that calculator. There's actually one that you can get for an Apple product now, and you can download it through their store and try and figure out what your child support is now. With that kind of opened up some floodgates with some problems that would occur. Whereas we would try and look at mom's income, dad's income, and figure out what they should be. Well, what we see sometimes is parents try and cooperate. They don't want to be in court. They don't want to go to court and litigate something. If they've got an agreement and it's working, that's what they're going to do. Well, the problem comes up that mom and dad have this out-of-court agreement that I'm going to pay you $500 a year or $500 a month in child support. And then dad starts dating again, mom gets remarried. For whatever reason, it blows up. The parties can't stand each other. And they want to go back and go to court. Well, the court is then going to say, well, we've got to figure out what your child support is back to day one. And then we get into, with this calculator, because it's not a flat percentage, then we have to look at, all right, in 2017, what was dad's income, what was mom's income? Back in 2016 to 2015, all the way back to the birth of the child. So we can figure out what the support obligation was each year. Then we're going to add in all this interest, where it's going to compound yearly at 12% interest on these child support orders. And what was happening was someone would go into court, and it was not unusual to see a dad or a mom, but most of the time a dad, get hit with 10 years of arrearages. And by the time you put the interest on there, we're looking at 6 figures. We're looking at something that the dad just can never dig himself out of. And most of the time, this comes from a situation where the parties had an informal agreement of some type. So what our legislature did was, the first thing is public chapter 145, and I brought notes so I don't screw it up. This lowers the mandatory interest rate on judgments of child support to a maximum of 4% and as low as 0%. The problem I see with that is every other judgment in Tennessee has a higher cap. So if you go to court and you get an attorney's fee awarded to you, what interest rate do you get on that?
Well, I'm thinking it's 10%.
Yeah, so if there's not a contract and you get a judgment, it's the same thing. It's somewhere between whatever the contract rate is up to I think it's 12%. And what we've done is we've lowered the amount of interest on back child support to 4%. What we've in effect done is told deadbeat dads or deadbeat parents, you can pay me last. My interest rate is 4%. Pay your American Express pay your Visa first, pay everything with these high interest rates first. I'm only clicking away at 4%. Now the opposite side of that argument is that a dad can dig themselves out of this hole now, because instead of this massive amount growing at 12% compounding annually, it's only going to be growing now at 4%.
Right.
And you can actually make a case to the judge why it should be lower than that.
Well, in my thought of it when I hear this and look at it is I've got individuals that they're retired and they've got, they've had a $50 a month payment for years done by Magistrate Woods, which it's been a long time since he was in juvenile court.
Sure.
And they're sitting here, their kids are probably in their 40s now, and they've still got a $46,000 that's owed. And
it's clicking away at that higher interest rate.
At that higher interest rate. But the other thing with it is because the other parent, the parent receiving the child support, went in and asked for 4D aid under the Social Security Act, then you have the state contractor revoking the person that owes license and doing all these things that if I was just collecting for a regular creditor at the 10% interest, I couldn't do that.
That's right.
So it's one of those that in recent years what we've seen is we've got where you can get a restricted license so you can get to and from work if it gets revoked and you owe child support. And then some of the other things where if you can get everybody to agree, then you can lower the arrearages amount with a lump sum payment, except the problem with that is if the state's involved, they won't agree to anything, is what we've realized since that came in. But, so, I mean, it's one of those where, are there any good solutions?
Well, the good solution is if you know that you're having a child, go down and establish if you're having a child out of wedlock, you need to establish your child support order as quickly as you can.
Right.
Because the sooner that you establish that order, the less interest you're going to have. I mean, if you bury your head in the sand and for whatever reason you and mom are getting along, or what's the great line? I don't want that money. I don't want your money. All you're doing is allowing this interest to compound, and you're just making it harder for yourself. Get it done on the front end. But if you wait too long, the good news is now it's only at 4%.
Okay, that's a great place to stop. So when we return, we'll continue our discussion about family law. Stay with us.
Cinderella found the pet that fits her perfectly. Tiana gave her pet the royal treatment. Belle found beauty where no one else did. And you can too. Share your heart. Share your love. Bring home your forever friend. Make a shelter pet part of your world. Happily Ever After begins at theshelterpetproject.org.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Bill Jones. We're discussing updates to family law. So, Bill, we got through the update on the percentage on arrears
Yeah, I
and
think
child
that took us a
support.
little bit longer than we
Yeah.
anticipated, so I may have to roll through some of these other ones. The next change kind of works hand in hand with that percentage rate because, as we talked about, the larger that amount of arrearage is, the faster it grows with this interest rate. Well, what this new law does is Public Chapter 419, it provides a 5-year limit on child support arrearages. It basically prevents a trial court from awarding retroactive child support prior to that 5-year period of time. Now, for good cause, a party can go in and show, well, we've got an extenuating circumstance. I need to have 10 years of arrearage, but the baseline is going to be set at 5 now. So, and a court can actually shorten that if they think that equity and fairness demands that. I've got a case right now. A gentleman never knew that he had a child. There's some argument over whether or not he should have known, but the child's 15, and dad is now looking at having to pay 15 years worth of arrearage. Well, if it's if it's $10,000 a year in child support, he's looking at $150,000 of arrearage, which just isn't manageable. Even if it's only growing at 4%. So what the courts have said is, look, we're only going to look back 5 years. We're not going to look back 15 years. Now, this law is only in effect for matters that are filed after July 1st of this year. So if you're watching at home and you've got a case like this that was filed, in April or May, you're out of luck.
Right.
These cases are only ineffective going forward. But what this does is this does not penalize a dad and a mom who have made this informal agreement. Hey, I don't want your money, or just pay me $300 a month, or whatever they've agreed to. And then, for whatever reason, things blow up, they go back to court. They're not going to go all the way back. They're only going to be able to go back for that 5-year period. And I think that's the right way to look at this. Again, that working in conjunction with the interest rate does give an incentive for you to get in on the front end and get this child support order entered now.
Well, in the 5-year look back, I think incentivizes those that would receive support, if you need support for that child, to go in and get it taken care of.
That's right.
Because, we've heard of these horror stories where somebody waits until the child's 19 or 21 and then files for child support. So after telling somebody, oh, that's not your kid,
Yeah.
and then, oh, it is your kid now, and I want 18 years worth of back support.
And I guess we need to explain, that's the way the law was set up. The way the law was set up is that if you thought or possibly knew that this could be your child and you never did anything, mom could go in at 19, 21 and say, hey, this is your kid, I know for sure, and I want child support back to the date of birth. She could get it.
Yeah.
And this puts an end to that.
And attorney's fees to boot.
And attorney fees to boot. I mean, it's almost, look, the deadbeat dad, it exists, okay? There are fathers who try and get out of paying support. And this law is not written for those individuals. They may benefit from it. This law is really written for those dads who have a difficult X who, maybe it was we call it in the office a hit and run. They just hooked up, had a child, and no order was ever put in. This law is written to try and give him a chance to where he is not saddled with this child support for the rest of his life. Because in that situation that we're talking about, where at 18 you're going to get 18 years worth of arrearage put on you, you're never going to dig yourself out of that hole.
Especially not at 12%.
Yeah. And you're not going to be able to be a parent at that point because you're going to feel so much guilt, shame, or anger at the other parent that you're not going to be able to co-parent. You're not going to be able to enjoy your time with that child. Every extra cent that you make is going to be trying to go towards a debt that's 18 years old. This law kind of does away with that and really allows people to enjoy their time with their kids.
So what are some other changes we've got?
All right, so then we've got Public Chapter 300, which is kind of interesting to me. This allows the state to seize 50% of an inmate's commissary account to satisfy a judgment for child support. So it used to be that you just couldn't touch it. But now, if you've got somebody who's on the inside and they've got a commissary account that their new girlfriend or their mama keeps full, well, you can seize up to 50% of that to try and cover some debts. Hopefully that won't affect too many people out there.
Well, and I have to say, I have a certain segment of my clientele that are the non-incarcerated parent, and they're trying to just get something to get by. Yeah. And this will actually help them.
Yeah.
So.
Well, it's there. Again, I'm hoping that there aren't too many people that benefit from it, because best as I can tell, these commissary accounts aren't very big, are they?
Well, they're not, but the thing is family members are going to refill it. So this is where, when I read this, I'm sitting there thinking, oh, well, if somebody's smart that wants to get 50% of that commissary account, they call up everybody that cares about that incarcerated person and says, hey, you need to put some in that commissary account. But, that's all.
Load up the commissary account, call everybody and say, hey.
The question is, I don't know if there's a limit as to what can be in the commissary account or not.
I don't either.
So.
That'll be interesting.
Yeah.
Do we have time for another one? Let's see.
I think we're about to take a break here.
All right.
And then we'll come back. When we return from our break, we will talk more with Bill Jones about family law.
Can you help me with this? My new dad teaches me all kinds of stuff.
Sure.
He helps me with homework.
That would be 3.6795.
Thanks.
Yep.
He helps me with my decision making.
I wouldn't use this one. Ever.
And he's even teaching me how to drive.
And that's why cars have bumpers.
I'm learning so much.
You don't have to be perfect to be a perfect parent. Thousands of kids in foster care will take you just as you are.
Taking care of a family member can lead to plenty of questions. Fortunately, there's a place to get the answers, for them and for you. Find articles, tips, and tools from experts and others who have been in your place. The Caregiving Resource Center at aarp.org/caregiving.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is Attorney Bill Jones, and we're talking about family law. So, Bill, we've talked about some of the differences with child support and the collections on that.
Sure.
There's other changes in family law.
Well, there's an interesting, and we'll cover this one real quick. There's an interesting change to the Tennessee Rules of Evidence. There's a new advisory commission comment to Rule 611 that allows a court to permit, I want to get the wording right, to permits a witness to have a support animal toy or a support person present when testifying if the witness would be at risk for being unable to communicate ineffectively. So what we're talking about is a child up on the stand who, for whatever reason, is having to testify. They can have their support animal, they could have, their favorite toy, or they could have somebody stand next to them. I'm curious to see this in play. I don't see a problem with a support animal. I don't see a problem with a toy. But when you start dealing with a person, who's it going to be? I mean, if we're dealing with a person that has great influence over the child, or somebody that the child doesn't want to disappoint, I could see the potential for this allowing some abuse of this system and putting somebody who could intimidate the child. Because look, kids don't want to disappoint their parents. So many times in custody disputes, I hear, well, this child thinks this about dad, or this child thinks this about mom. The truth is, the kid loves both parents. And if you've got a parent standing over or hovering over that child under this, that child may feel uncomfortable stating their true preference or testifying how they would need to. So I'll be interested to see how that comes into play.
This is where I trust our judicial officers to realize that and
to
do
try
what
and use
they've
some
always
discretion.
done. When in juvenile court, we've had a 9-year-old that had to go on the stand.
Yeah.
And the attorneys sat in, the judge talked to the 9-year-old.
Yeah.
And the parents were out of there.
So it's all about protecting the best interest of the child, and I hope that the courts continue to do that, and I think they will. The circuit and chancery court, where I deal with most of my cases, the judges are always pretty good about doing that.
Well, my take on this statute comes down to this. We got the maximum participation, the best interest of the child law come through. And the way the judiciary applied that is that's great that you guys said that. I'm going to do what I've always done. So,
yeah. And that's look out for the best interests of the child.
Yeah.
The next is the last change I think we've got time for. It deals with property division, and it deals with closely held corporations. So you've got a closely held corporation, and if you want to discount it due to it's not marketable, you don't think that your business, there's any buyers or you get a discount. You can build that in, even if there's no evidence that there would be a sale.
Yeah, so this functions the same way as it has for years in estate planning. The IRS has recognized a lack of marketability and a lack of controlled discount when valuing somebody's estate. And there are just some companies that they're not set up to where you can sell them. You can't liquidate them. So the question will become is what's the appropriate percentage of discount?
Well, so most Americans don't have a closely held corporation. Most of my clients that come in do not have a closely held corporation. What they've got, though, is a piece of property that they own. So we own a house together. My wife and I own a house together. We want to get divorced. I want a share of the equity in that house. Okay? How do we determine that? Well, whatever is left after the sale of the house is what the equity is. But if one of us wants to keep it, then we have to pretend and pull some number out of the air and say, well, this is how much equity's there. Now, I'm not allowed to discount it and say, well, we need to discount that equity by 7% sales commission, 3% closing cost, and a couple of percentage for a closing fees for the lawyer. I don't know why, but this law only affects closely held corporations. In my mind, the next logical step is to apply it to real estate and say, even though there's no talk of a sale, common sense says that even though you want to keep it, if we were to go through the exercise of having to sell it, you would get this 7% discount, you would get this, and you would get this. But right now, if one party wants to keep it, in a trial court setting, you're not going to get that discount. Now, we could maybe talk about it in an uncontested divorce. Sometimes you're allowed to. But in my mind, the next logical step for this change to Public Chapter 309 is to apply it to real estate. And I haven't had an opportunity to do it yet, but the next time I'm in trial on it, I'm going to try and draw the correlation and show that a closely held corporation getting the benefit of a sale when there is no sale, that my client should get it on a house. Does that make sense?
It does, and I think your client would get it on a house like 50% of what that realtor fee would be.
Sure. That makes sense.
You know.
Maybe that's the better argument.
And I think it's one of those that they're different calculations because one goes to the straight valuation of it, whereas like with a house, you would just have a straight appraisal.
Yeah.
And then I think you would be able to say to the court, well, look, we need to back the equity out because if we sell this, then this would go to the realtor and this would go to this fee and that would go to that fee. But I think your countervailing argument on it for opposing counsel would be, well, if my client is forced to sell the house, they've got to eat all of that 100%. But, you know.
So the absolute last change is that there...
We got 1 minute left.
Okay. Well, 1 minute's all I need for this one. The last change is they've updated the Supreme Court forms that individuals can use if they are foolish enough to try and do their own divorce.
Okay.
There are forms online where if you want to try and do it yourself, you can. It is so difficult, I don't see many of them actually getting through. Hire a lawyer, let them look at you, but if you want, the forms have been updated and changed. Where now if you've got kids, you can try and do it yourself.
Oh, they're now allowing that? Okay.
That's the last change. But if you've got kids and you do your own divorce, what's he who has himself for a lawyer is a fool.
Well, what people are doing, they're filling them out and taking them to the Saturday legal clinic. And then the judge is having to deal with it in the divorce referee. But that's a whole different thing. So our time is up for this edition of Law Talk. I would like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more legal topics. Until then, I'm Vince Perryman. Thank you for watching.